One after this, the other else infinite abuse, and after setting norms, to drop the beta, one else short of the two short of the time period of the obvious 6 minutes, 2 non-mixing before we have competing into so those 2 non become the after hours, while playing defense after his first month larger strategic loss for a minute shells, 1/4 of the 1 versus 1/7 of the 1 C, 2 the goal of the determine truth of falsity of the solution fairly 1, because it is the value has to either go after a basis given resolution dictionary.com defines to the game as an attitude, and to affirm us to maintain as true, which means it's intrinsic to the nature of the game. It's a jurisdictional issue, but the question is whether the judge should go outside the scope of the game, and SK 12, the affirmative governs the obvious resolution is true, the negative presents arguments, resolution is false to inclusion, encompasses many impacts like forms of vowels, but like the videos determine what matters to the round words. Other rules of vowels may only include one, in Kuwaiti normative framework, only moral truth matters because the word is just the resolution theory. First outlets because we can't decide the role of vowels, one, the round was unfair, this is an incongruence to the ability to evaluate the round. 3, fairness first, a constituent of the debates of competitive activity which makes fairness and intrinsic good speech times cost as a winner lose all prove, be self-defeating. Every argument actively concedes the authority of fairness by pursuing the general value fairly absent of reciprocal judgment debated relationship. You can just hack, see evaluation fairness is embedded on your ability to evaluate the round. If one could debate had an advantage over another, it would be incongruence to the ability to prove the arguments, which means no cross-apps for admissibility, presumption of form A, which makes it impossible to take neutral actions like walking sense. We need proactive obligation, be likelihood of statements are more often true, i.e. if I said, my name was Levin, you believe me, C, safety, logically safety, it says it's better reason to go out into the mission obligation, D, epistemics, otherwise you can't start reasoning, so you have to question that reason, can't operate without any plus 5, interpretation to the negative, must concede affirmative framework of potential level offense, it's preemptive, you violate by leaving towards offense, to the defense of my offense, and then all framework of hijacks, before strats QA, it's impossible to one out to win both players, the Fabian offense, we just Fabian on video, which turns the advocate the round impossible for minutes, especially truth as 2 knock thoughts in either framework or connected for 6 minutes, 1 SCI, time allocation after disclosure, infinite round time, irresistible access to KG, CPs, etc. All exacerbates you all around solve your offense, because you choose to connect different layers, drop the video on what is theory, the points to the video, no obvious, it is not violent as well. Framing. The meta-ethics is non-natural, and one of the natural fallacy examples good fails by the ultimate good moral way. Good is capable of any definitive has no voice, good is a simple to define all considered element, trying to find elaborations within operations, simulated to the all things good, also something else. Too many factors, other properties actually defining good, too epistemology, only non-natural is epistemic and reliable, empirical facts of the world are mediated by sensory experiences, not directly connected to the truth and reality, self immediacy. There are 3 ways categories, the substance of these non-natural properties, internally, externally, or from constituent and related as beings. Internalism and externalism fail, only constituent can solve the deficiencies. That's how this will be. Internalism struggle universal normal case, so we try to wonder how to claim there is no relation to anyone, what is to look at externalism, generates universal normal claims, it encounters problems of practicality and crudeness, constitutionalism agrees, truth depends on aims, however, trace the authority of aim, that is constitution. That was practical reason as the basis for ethics 1. Infinitely, we're going to ask why for any other purpose, but to ask why for concedes the authority of reason, reason are inescapable and binding, and outweighs reason, the only ones that can guide action, which is the purpose of ethics 2, inescapability. Every agent intrinsically values practical reason, legal by setting and pursuing it, and there are more 3 presupposes the end of committing is an intrinsic good that necessitates practical reason as a necessary means to follow through any given end. That specifies the universal moral law. 1 absent universal ethics morality becomes an arbitrary system immediately applied without reason. Without arbitrary system society, only non-arbitrary principles can hold agents culpable for the actions, otherwise we can make them different ethical rules for different situations upon people. 2. Contradiction of pure principles like reason applied to everyone that's independent of human experience. That means you allow one to violate a rule like without another would be a contradiction. Contradiction is always side because it's an inescapable condition that undermines all arguments that something can be both true and false simultaneously. One reason being sufficient is the only way to avoid contradictions. Be accorded. A sentence like polygamy is morally wrong is true relative to a frame. Indexing moral truth does not assume disagreements and contradictions. Therefore, in order to respect each agent as a practical reason to decide, it requires that a universal moral laws with the category accounts of the violations of principles, rational reflection. That's a categorical imperative. It has 4 formulations. But no, 2. A theory of good lies in the categorical imperative act of the maximum of the action will become universal law as to humanity as an act as if you will can regard itself as making all foods maximum act that you will law making under a keen over heads. However, we require an enforcement mechanism for these principles since rights claims can't exist in the state of nature. What follows is the omnilateral rule. Vote 10. Wherefore, the actions impossible in the state of nature, be a sin of abuse, violence, since each has their own right to do what seems right to them. The only the public authority is only promise of ineffectivity because it represents the will of all, known in particular the public authority is united up here being omnilateral will can regulate on behalf of everyone. All actions can be subject to universal laws rather than anyone's arbitrary choices. Thus, the standard is consistently with the categorical imperative as enacted through the omnilateral rule. Attention. By advocating acts, I contend that resolve in the United States criminal justice system, plea bargaining is just. Resolve is defined as so firmly determined to do something. Per Oxford dictionaries I'm determined to affirm so about my vote, and I'll defend that purposes on spec if they don't cause me to abandon my maxim. 1. Plea bargaining expands defendant freedom. The sentencing cap does not make the choice coerced. Young 23. Coercion is not about the quantity of influence, rather the kind of influence or choice. Wrongful of it interferes with freedom. We are coercive in any situation that denies the person options given rights. Hard dealing, largely consistent punishment between threat and offer. Suppose the threat nor offer was unfair with the gap was wide enough. It's not hard dealing, rather the fear that is unjust. Imagine the defendant facing a stiff sentence, steps to the slap on the wrist. Rule not to the defendant was coerced. Offering is equivalent to threatening, not changing options available to him. We should not fetishize over defendant autonomy, confuses objectionable cases for injustice in institutions. Skip the 2 point for now. 3. Plea bargaining treats defendants no worse than jury trials. Criminal defense to innocence. Young 23. Wrongful conviction is inevitable. Any system of justice for weight of wrongful conviction is sufficient to answer arbitrary recommended jury trials to assume trials deliver morally acceptable results. If enough plea innocents would be convicted anyways, or if non-plea innocents go down to be convicted, plea not actually was left with the empirical gap that makes plea have a special innocence problem. Could it consider with greater discretion the better response is to limit that non-declare plea unjust method? One, to account for all preceding effects will prevent action because the individual will become morally culpable for all action in states of affairs not that the fact that will. Two, otherwise ethical theories hold agents responsible for consequences external to the will removes any reason to be moral because agents cannot control what they may be punished for. Three, aggregation impossible. There's no way to quantify different amounts of pain and pleasure. How can two headaches equal a migraine? Four, induction fails. It's incoherent and justify the past and justify the future because there's no logical certainty what has happened before will happen again. Five, consequences are empirically impossible to predict. Minat 05. A long-term study of 284 people who made their living off one of some political economic trends. The experts made a 2003-61 forecast. The experts performed their worst and if they assigned equal probability to all three outcomes.
Okay. I did not read that too. Didn't read too much. Okay. Go to cross.
Yeah.
All right. Start now. Can something be simultaneously anti-black and also just?
I don't know. Can it?
I'm asking you a question.
The 1AC doesn't have a stance.
The 1AC doesn't have a stance. So
yeah.
Wait. So is anti-black unjust? Is anti-black is unjust?
Kant says yeah.
Kant says yeah. Okay. So if we prove that plea bargaining is anti-black, is it unjust?
Well, you have to read Kant.
Wait. We have to read Kant. Wait.
No, you have to read. I say, like our interpretation of the round is that we should frame the round through Kant. So if you want to make the argument
wait, but you just said that
it's unjust, then you should.
You just said that if we prove plea bargaining is anti-black, that is Kant offense because you said it's that means that the resolution is unjust.
You can make that argument if you want.
Okay, that's fine. The rolled ballot, what does it mean to determine the truth or falsity of the resolution?
Yeah, so basically our interpretation is that we should fairly determine, the ballot should fairly determine the truth or falsity of the resolution. In other words,
I guess what does it mean
the
for
resolution
something?
is true or plea bargaining is just, that proves the resolution is true.
What does it mean for something to be true?
Yeah, so it means something, like if you prove the resolution is just, that proves it true because the word is just is in the resolution.
Okay, that's fine. I guess I want to talk about the framework. I guess non-naturalism, why is it true?
Yeah, we have two words in case. You want us to read this?
Yeah, sure.
Okay, sure. The first one is the naturalistic fallacy. It's impossible to define good because they fail to define evil to make good. The moral of the code tells you that good is incapable of any definition because it has no codes. When we give the example in case, consider the color yellow. We may try to define it by light vibrations, but that's not what we actually perceive, so only something non-natural.
Okay, that's fine.
The second one?
The offense, that's fine. The offense, why does the offense occur?
Yeah, sure. So the first piece of young point, the evidence tells you that plea bargaining actually expands defendant freedom by giving them another choice, which furthers their autonomy. It uses humanity, it treats humanity as an end, not a means to an end.
Is coercion offense under your framework?
No, the coercion stuff is preempts.
Wait, I mean, is coercion offense under your framework? Like, is coercion morally relevant under Kant?
Yeah, I would say so.
Okay, that's fine. I guess. All right, contradictions. Why is it a side constraint?
Yeah, so basically a contradiction. So if you create a contradiction, then that makes no sense, right? Because it's an inescapable condition. It undermines all things. For instance, you can't say 2 plus 2 equals 4 for me, not for anyone else. That's a contradiction because and that violates the celibacy.
All right. So if negative wins a single reason why Kant negates, is that sufficient for the judge to go negative?
No.
Why not? I thought you said side constraints. I thought you said contradictions or something.
Yeah, so you can waive.
Wait, but if I win a reason why Kant negates, that
it's a side constraint. Obviously, they can't both be true, so you have to determine which one is true.
Okay, that's fine. That's good. I'll send the ones.
Great.
DocuSign. It's going to be one off, and then case starting with the overview. Then it'll go to the framework. Then I'll answer the AFC ACC shell right before I get to case, and then the last thing on the case page is the offense.
Wait.
I need the order on case again.
It's going to be the overview.
Okay.
But the shell, I'm not going to answer it there. I'm going to answer it right before I get to the offense page. So it's going to be overview, framework, the AFC ACC shell, and then the offense, like the contention.
Okay. Okay.
I'm good with
Let me just check that I got. Okay, yeah, I am good.
Alright. Colonial penal law relies on Eurocentric definitions of crime as deficits, criminals as non-citizens, and justice as punishment. The money seeks attempt to increase efficiency, improve performance, and uncritically accepts furthering the ideologies of racial inferiority and discretionary police power used to justify invasion, dispossession, genocide, 2023 colonial definition of crime, exposed foundation, state invasion, fortune, length of genocide. The question criminologists ask for increased efficiency will improve performance and necessity taken for granted expectations of what constitutes a law-abiding citizen, continued creation of inferiority with only necessary basic concepts of dysfunction requirement for personal intervention to justify the appreciation that outcomes were created through insane dispossession for stable orders, crime, whose criminals based on positionality for creation of genocide. The answer is not. Those who are convicted in courts, we exist in a way absolutely universal. Policing the code line is synonymous with maintaining law and order. Presume when our response is false, don't like people directly benefit from racial domination, insert social networks, racialized pools of knowledge, and angelized stereotypes, perform as symbolic, exponential, structural, bias towards legal and endearment, volume 24, policing the code line is common sense response for maintaining law and order benefits white people direct from racial started through structural dimensions. Legal endearment and social equity viewing policing as racial domination narratives index, disparities and natural consequences by dismantling Jim Crow laws, legacies, persist segregation, an actual project that involves the policing of white space, geographic targeting of minority communities through policing and devaluation, inverse mirrored in white areas, police have more power and background neighbors often function for code for black ghettos. White Americans, 91% of their social networks were white. Where white studies suggest that whites part of acquaintanceship shows higher degree of segregation. White epistemic universe produces racialized pools of knowledge. Insert networks amplifies perspectives while suppressing evidence to the contrary. Contrary abstract appeals to hope for better futures or reproduce Eurocentric visions of progress, erasing structural violence and disciplining subjects into colonial categories of violence. The future cannot be viewed apart from social patterns that materialize capacity to inspire by raising hopes of people suffering from colonialism. People follow their colonizer aspirations and condemn to fatalistic despair because people unable to hope for themselves. Societal hope entails cool optimism and attachment to compromised conditions, shaping the desire of subjects reproducing entrapment, anti-colonial hope, practice alternative hopes of those whose future cannot be captured in language of coloniality. Epistemic practice reproduce hope. And coloniality practice requires new classical relations and acknowledge body knowledge and rewarding student resistance. Students envision new global imaginaries that challenge coloniality. Students should be offered opportunities to enact hope, assigning moral legitimacy to judicial decision-making, in terms of white epistemology law, in terms of racist value system, units from the legitimacy laws, judicial system-making to create racial inequality. Theories of moral legitimacy argue that legal regimes are sufficiently just to deserve support. Absent better alternative societies can be moral any explicit claims of racism. Courts shifted towards race neutrality, silence discussions of subordination, masking racialized processes, normalization of ideas that center white epistemic judicial decision-making have moral legitimacy only because it no longer appeals racialized social rights and wrongs and normalized values, so which justify racialized decision-making. The alternatives framework integration out the value could be performances in basically would link anything else being less racism is possible and exhausting to prove interpersonal violence outweighs extinction, excessively outweighs denying it. It's ultimately unfair because facing engagement possible and here is a correct for any of debates benefits matter for one to be shaped so should be shared 22 forming the belief is value-based decision problem brain engagement and unconscious calculation. People believe that the view of the highest utilities actor believe that any observed and reinforced learning which parts of the learn which he was associated with the greatest word police will have high value because of internal and external outcomes. Choose golden rule. You shall initially reject racialized practices requiring you be 100% certain to act against it and will lack that magnifies exhaustion by saying signal to zero recourse from racism invade voting negative refuse not hold races accountable which reverse causally solves 3 is norming. Evaluating models ensures best norms disclosure power exercise plans. Negative theory case would have been incomprehensible 20 years ago, but individual decisions normalize them. Proven by race war become popular after caliber believes crowds luminosity case show up 100 times over gate, etc. Alternative accounts like lacks expand toward power for jurisdiction judges. Our educators in paradigms are geared to an educational audience which is us. Whose our impacts on jurisdictionally power. Paradigm 24 paradigms are geared to an educational audience. Hateful language is forbidden. Be mature educators and good people. Case. Although review rejection assessing what is racism prevents calling out representationally racist practices because those targets aren't related to resolution. 2 is introduce advanced theory that isn't about the topic which prevents calling out practices like infinites or word picks. 3 rejecting racism is constitutive above. 4 they should lose for side of the handbook explicitly says it's not a rule book. There evidence says there is no way to debate. Please do not consider this as a rule book. Rather debate from splitting negates. A negates deny the truth of. So the negative can disprove an obligation through permissibility since the one must have been an active obligation to act. B black obligation proves the resolution false. It says you have to prove obligation that but you cannot be obligated. Lack obligation simultaneously. The words are wrong. The first one is wrong. You don't need it. Practical obligation for every action. The second one is wrong. Not true. I assume your name is Jeff. And the third and fourth wrong is warrant is wrong. It's because very skeptical. So we are misled. Framework. 1. 2. 3. 4. 5. 6. 7. 8. 9. 10. 11. 12. 13. 14. 15. 16. 17. 18. 19. 20. 21. 22. 23. 24. 25. 26. 27. 28. 29. 30. 31. 32. 33. 34. 35. 36. 37. 38. 39. 40. 41. 42. 43. 44. 45. 46. 47. 48. 49. 50. 51. 52. 53. 54. 55. 56. 57. 58. 59. 60. 61. 62. 63. 64. 65. 66. 67. 68. 69. 70. 71. 72. 73. 74. 75. 76. 77. 78. 79. 80. 81. 82. 83. 84. 85. 86. 87. 88. 89. 90. 91. 92. 93. 94. 95. 96. 97. 98. 99. 100. 101. 102. 103. 104. 105. 106. 107. 108. 109. 110. 1 One on non-naturalism is linked to K, attempted to sever out of naturalist facts like race of hate, recurrent suffering, and perpetuates anti-blackness. 2 on more 3, the ultimate good is established a world absent Western colonialism because it will always be the root cause of violence. 3 epistemology is linked to K because attempted to imagine a perfect application for philosophy, ignore structural claims of racism, and why it was imperfect in the first place. 4 on correspondence, trying to universalize reasons linked to K. And was on above B, the attempt to bind agents to intrinsic facts like is linked to K because it's an attempt to mold agents to be exactly what the state wants them to be. 5 on binding is A, binding agents to a certain idea is bad and was done above B, utilizing one constituents is good. C, RK allies agents to decide against other values like racist values, which we then get guide action. D, some agency objection, shifting out of constitutional obligations. And B8, and be an agent. And 6, normativity is linked to attempt to justify and compare racialized violence through normative frameworks is bad and reproduce violence set on principle of equality. A, to attempt to universalize ideologies in the form of Western dominance and links to the K. A, on a priori. A, using a priori logic is an attempt to ignore historical claims of racism, which is linked. B, is augment. We agree it is doesn't imply odd, but we still need to account for material conditions to apply principles. 9 on Varden, incorporating Kantian fill is incorporating Kantian fill into the alt is bad. Responding to theories homogenizes all cultures together, which is linked to K. And really, if we want a reason why your framework produces anti-blackness, it means that your framework would corrupt the alternative. 10 on the categorical imperative. A, abstractions are linked. You don't account for empirical circumstances and abstract away from reality of certain people struggling more than others. Definition of all lives matter. B is the link there. Pure theory can't explain what to do in the face of a freedom violation. They only say that others shouldn't violate it, but that is useless because violations are inevitable. Now, the AFC-ACC shall counter-interpretation acting contest both the framework and offense. One is if abuse, they can choose framework and offense. That is practically the same. And you can see one to prove the other true. Choose critical education. Critiques are impossible. If I have to concede, must have been the topic and framework that is ideal. Case are good. Crossed by everything above. 3. Your interpretation is fundamentally irreciprocal. I can only contest one, but you can contest anything on your word, non-unique. Because I'll contest framework, offense, or read theory and contest framework, which means that your interpretation can resolve the standards. No one error theory. It's you have 4 minutes and 3 minutes which will overload the turn because the 7/6 skew, and you should use RBIs on 1AC theory because you should be able to defend a norm that you thought was so good that you put in the 1AC case. IDA resolved in the United States criminal justice system, plea bargaining is just, non-contradictory society constraints, something cannot be just and unjust simultaneously, which means if I win one piece of offense, you should gain one. Universalizability, if everyone plea bargain, moral responsibility will be multiple area accused person, which is a trial, which destroys the link between guilt and punishment. 2 is coercion. 625. Plea bargaining exacerbates hard to approach trial sentences, all Region Act, or to refuse to reproduce existing punishments, maybe to plea bargaining, opening lobby. Legislation should increase hard sentences to give them electrical plea negotiations, prosecuting knowledge of the role. That plea bargaining pleas in hard to be assigned sentences, cut sentences, 3 proportional punishment, do them, 20 retributivists, break the law, commit a more wrong punishment, and impose the reserve harm to every inflict as a means to promote good for the criminal himself only because his current crime seems to be justice and can be bought, it may not impose the punishment. Better punishment. I didn't read 4, 5, or 6.
Great. Good cross.
Yeah.
Good. Great.
Let's talk about, I guess we could talk about
Okay, boost. What is your interpretation? How do you win?
we think that the representations of the 1AC should come prior to the consequential impacts, even if you prove that your methodology is good. If we win that your representations were racist, then you should vote negative.
Okay, sure. I guess, let's see. Why is truth testing racist?
Because your model of truth testing means that we can only make arguments based on the truth or falsity of the resolution. If
Did
you
we say that?
Sorry.
Like, did we say that in the 1AC?
Yes.
Really?
Yes, you said that truth testing is the only constituent feature of the debate.
Great. Okay. Permissibility. Are there any permissibility to this?
Well, every reason for why the framework is wrong and why the case is wrong is a permissible feature.
Okay, sure.
And every link of the K is also a permissible feature.
Non-contradiction is science rate. What is that?
Well, you also warranted in your own 1AC. Our argument is that if we win a single reason for why Kant negates, then you must also negate because something cannot be just.
Like under
Yes, under Kant.
Okay, sure. I guess you only justify LVI on 1AC theory, right?
Yeah.
Why?
Because if you read theory shell in the 1AC, you must have read it because you thought the norm was so good, which means that you should be able to defend the norm.
So how do LVIs check that?
Because if you
do it only.
What do you mean? Because if you don't go for the shell, then you should be punished for not defending it. Like if you defend a bad model, then you should be punished for reading it in the first place.
Okay, sure. I guess. I guess we can talk about What does it do?
The alternative is to reject the negative, reject the affirmative if its representations are racist.
That's it?
Yes, that is what the alternative is.
Do you make it ontological? Let me see.
What do you mean by that?
Like, is progress possible?
Well, that's not what ontology is, but our argument, we have made a structural claim about Western forms of legalism. We think that progress within forms of legalism and Western jurisprudence is bad, and we
Is
think
it
that-
possible?
Well, we never made a claim that it's impossible. We just said
Do
that.
you think it's impossible?
Well, yeah, we think that forms of legalism in Western approaches are quite bad.
Okay, all my question. Sorry. Please talk about 108. I'll send the call. How is that? Let me know the offer.
What's over?
The order, 1AR theory hedge, you off, truth testing, and the K-pop.
Hold on, I'm gonna read that repeat, but mean is. Okay, I need the order again.
Okay, the order, 1AR theory hedge, you off.
Hold on, let me just. Okay.
1AR theory hedge, you off,
Uh-huh.
truth testing page, and then the K. And the order of the K is just like an overview, the overbalance, beyond that notice.
Okay, just signpost, because I did the entire app on one page, so.
Okay, yeah, sounds good.
Oh. Okay, I am.
Good. Okay, great.
Extend 1AR theories will do any else means infinite abuse in the app, never stepping noise. Extend dominant beta 1AR true to rule to make the time to have no obvious 6 minutes to know these brute force me every time convenient to so those that do not draws the app arguments. Role playing defense after 3 plus 1 color, 63 plus 1 for the 1AR versus 1 7 the 1 C 7 6 Qs fine. After splitting, we have to respond in 6 minutes of content with 3 minutes after flexes. These are forming is harder that's in the shell. K, CPs, T, 1 4 minute 1AR all proof faster respond to arguments than the make them because proving something false only requires one counter example. RBI 1 AC we know we'll kick out of it. You spend less time responding to us than we did. RBI is illogical to win for being fair. 2, includes debaters debate abuse practices with the RBI. 3, disincentivize people from putting on legit abuse in fear of losing the RBI. The RBI was blipping in it. It specifically contextualized it to the 1AC shell, and if we prove the abuse in the next shell, actual abuse outweighs potential abuse on the RBI. So, the shell. Interpretation debaters must include the URL cited for the evidence. If a film book, they must have copies of it. The violation scrutiny 23 million, 24 is MBS 20 release, 23 China, 22 standards, 1 NSC rules, the unified data system to include the URL NSC 23. Responsibilities of contested security evidence with sortation for URL and materials must be available to the opponent of the ground. The interest of the rules to make infinite abuse outweighs the decision of rule debate that's truth testing also proves that shells predictable and reasonable. 2 evidence ethics with no to check whether the code exists or not. They can just make up whatever evidence they want. Independent voter choice to consider the purpose of debate as an educational activity to just make up a lot of evidence. They need offense, but why not include the URL that's obviously incoherent, that's all definitely for a URL for at least one of them. Truth testing. It outweighs. 1 jurisdiction and judges contact the rules of the game, no authority to change rules in the NBC world forming the game, and the versus win on the balance of the time, task through the policy and context of the West. It outweighs going outside jurisdiction is intervention changes and tones the world because the civics control to another body and makes the impact responses to be video by anyone who disagrees in educational space. So anti-black then submitting this question to the NBA is bad proofs even if the world is better. They don't because the data is proof how the game should work, not how it does. Line by line, not racist. Theory checks we made it in the 1AC. It's in the text. Theory comes forth. No infinite abuse. We say that theory checks in the 1AC. Racism is the impact on the truth testing. If they read a normative, look at an example, this is bad on the con. It doesn't treat communities and always in philosophical education because it forces them to read an actual framework instead of just and mindlessly saying, oh, this violence is bad. So we don't just assume so. Jurisdiction tab has nothing to do with no ways in which tab exists. NSTA rules are way because it's Yale tournament rules as well as tab is conceptual. NSTA, IBI, NSTA is a different URL, which means the argument that the rulebook is incoherent. Look at the URLs in the document is a different URL that they're indicting. We'll concede that the thesis of the critique is correct, which excludes a Kantian worldview, but arguing that reading Kant independently is good because ideal theory critical terms rep stuff because we ask reading is actively the robust ethical systems teach by oppression law, otherwise echo chambers will ever presumptively consider the next bad justice because the people who need to change will never be convinced their actions are wrong, comments whether the violence is wrong, because the violation of freedom of a bad justifies the ideal theory critical to the concept of the one and see their interpretation unnecessary. They could have framed it on the truth test by reading the ethical framework of the terms, but they choose not to do so. The debate takes subjectivity wrong. The voting that doesn't actually do anything. Debate is a game designed to win comes all proven by the fact that tons of cases where people still read policy have extended fairness from the first one, but when you see those conceded fairness comes first because it's a meta history and your ability to evaluate the ground reinforcement learning wrong. There's no negating keyword, there's no look at the card. The golden rule, no 100% certainty is good because otherwise you make a wrong decision. Internal is unfairly calling people racist, incoherent norming to a new role about is not established in the debate states clearly. Even though tons of people's read case similar reasons to your case have been run thousands of times. They're rolled about no all framework to economies. They collapse it. You should turn it. This is IBI says there's no standing theory to resolve this skeptical one. Person want to see because they create worlds where we can't see violence is wrong because they only align the intuition that oppression is bad but can't actually based on the analysis of the status quo. Asking the judge for the ballot prescribes them as an authoritative model. Asking them whether or not your violence is oppression not meaningful enough to warrant when they're rolled about is scale and proves it's a question of how persuasive the judge thinks the offenses would require them to act as an all-knowing adjudicator because they want to see the alt censorship DA. Redaction is incoherent. Doesn't solve any of the impacts linked to it because whoever's deciding that redact is changing history and what they think is good says they think systems of racialized sensitive only proves that reform DA. They make it so that discussions about violence is because we presumptively agree certain things are good and bad while reducing engagement. Framework ultimately our framework justifies the because we explain what to redact and what not to redact. Intrinsically argument turn the institution they preserve by removing plurality is intrinsic ability of racist institutions. Conflict racially diverse turn perception minorities are told about this. The justice system is racist so they disengage and skip during the turn perception minorities are told
Yeah, sure. Okay. Are we doing 5 minutes?
4.
Alright, 1 minute start. What was this censorship just said?
The censorship DA says redaction, the alt is incoherent because basically it relies on this concept of it makes no sense. It doesn't solve the neg because it includes whoever's deciding whether the path or not is good or not. Only if there's this racialized ideas of censorship.
Wait, sorry, could you explain that one more time?
Yeah, sure. Your alt is incoherent. It doesn't solve anything because it just gives the ballot to the judge, and furthers like this idea of like power structures. Everything that 1 and C says is bad. It just furthers them because it treats the judge as an authoritative one.
Oh, you didn't go for the AFC AC section?
No.
What was the one for ideal theory?
Ideal theory good. Robust ethical systems teach why oppression is wrong. Okay. Otherwise, echo chambers were presumptively agrees to the impacts of that. But solvency because the tool would need a change from the way to convince the actions are wrong. Kant explains why violence is wrong. That's what I said.
What was the answer to subject formation? Was there an answer to subject formation? That's fine.
The new 1 AR shell?
Yeah. Also, I'm gonna send a rehighlighting of those. Okay, 1 sec.
You send it?
Oh, yeah.
It's okay, no additional.
Yeah. Okay, I'm good.
Alright, cool.
I'm going for framework extended interpretation of how computer performances in mood cases we would like anything else create violent environments as the impacts of racism can never scale up to outweigh hypothetical extinction scenarios and hypothetical extinction scenarios. The affirmative loses debate because they've conceived that racism outweighs and is an internal interference, which means that they have no offense on the shells because they've conceived that racism is an internal interference, which means that every time you say that fairness is a meta constraint or that fairness is paradoxical or that fairness outweighs because it's paradoxical, then you should vote negative because they concede that racism is procedurally unfairness and internal interference, which that it must outweigh. Conceded two arguments that was explicitly flagged on the interpretation. First is current racism denies access, which is ultimate. On first use makes response to arguments looking possible, and two is a prerequisite. A fair model is pointless. If we can't show up to it, so their impact starts at 0 if we win ours. Their impact definition cannot outweigh. Racism is unfair and extremely bad, and an inaccessible model is both unfair and racist. Our model is at worst only unfair debate 101 is that when our impacts cause theirs, but not for vice versa. Only we have first community offense, which is that by the end of this debate, if you think that we're avoiding a reason why the affirmative or what the affirmative did was racist, then you should automatically vote negative on framework because it outweighs all of the offense in the shells. The 1 year did not explain why theory comes first because they can see that K framework is also an independently procedural impact, which then must outweigh. Now, expanded subject information because it was completely dropped in the 1 year. Because it was completely dropped in the 1 year. Extend by ease. No biological and sensory motor parent prove that repeated beliefs habits unconsciously change our minds, even if we perceive it unemotionally for our evidence. I'm citing evidence. Citing scientists over trust mutual analytics from high schoolers, which proves that excluding links to representations leaves racist assumptions unquestioned, ensuring we internalize them, which makes us all racist. Which means that voting them down this round is neurobiological and changes to their own brain, which causes us to be less racist. Now, that was completely dropped, which said it must outweigh. The second argument going forward was also dropped in the 1 year. It extended multiple unconditionally direct racialized practices to remind me you'd be 100% certain to act against it with ethical lack of sacrifice exhaustion. By sending the signal there's no recourse for racism and debate voting negative refused to not only racism accountable, which first casually solves. Now, the K was basically conceded, and the 1 year was just incoherent, which means that it should set a very low threshold for the link. Extend Cooning, that was the Eurocentrism link. Plea bargaining is part and parcel of the genocidal and racialized system founded upon dispossession, slavery, or slavery, European colonialism, slavery, Jim Crow laws, and the over-policing of black populations have forced foundation of penal law that relies on criminals and non-citizens justice as punishment, while dismantling the systems of repression that create definition of crime in the first place. Questions like how we make force more efficient or improve performance in the criminal justice system. New plea bargaining naturalizes the partial state as neutral and necessary, which presupposes the necessity of criminal law and state violence, acceptance of the violent logic of criminal law frames by racialized communities and marginalized people as dysfunctional individuals and justifies further state intervention, which erases external conditions of violence. Now, the 1 year had no defense of plea bargaining, no defense of the criminal justice system, which means that you know this link is true because I know you have because the 1 year was just incoherent. You did not flow any response to this, which means that it's a conceded link, which is that insofar as they concede that racism outweighs not winning framework, then you just auto negate here. Even that I'll extend. Now, even that the next argument I'm going to answer is normative justification good? And normative justification good? Because that's the only winning we are in this debate. Now, there's two disasters to their model. First is reflexivity. They turn debate into racial fantasy. And then providing alternative perspectives to normative focus ensures unreflexive epistemic practices, having students be racially ignorant and refuse to question the biases, and be prone to manipulation, which is exactly what normative justification do, because they opt out of critical discussions in favor of philosophical justifications, which is racist and independently linked to framework, which means that this is also a reason what their justifications are like. Their justifications is racist, which is they should auto be under framework, which was the shower evidence above. Second is color violence, and color violence. They've conceded our evidence that forcing normative justification allows teams to get away with justifying the criminal justice system under the fact that it may be morally good in one lens, proven by the fact that they use constitutionalism in this round to justify the plea bargaining, which we said is racist, which proves that normative justifications are bad, which means that you should just presume the winner falls. Now, the last framing issue before I go on to the shell is the fact that they've conceded that you should move case if we win a link. They've conceded the quote from the interpretation that's specifically from our framework interpretation that says you should move case if we win a link, which is in the 1 and C, which means that if we win, that if we're winning the risk of link, that you just zero all of case because it was a conceded trick coming out of the 1 and C. Now,
They say now the censorship doesn't make sense. Just voting negative and rejecting racism in every instance stalls because if you're racist then you should be rejected even if it causes censorship because there's no impact to this which is that reject racism is good. They say people have read that case thousands of times. This doesn't matter because our argument is about it because they can see the golden rule which is that it's not a question of balance policy. It's just they should reject them in this round for being racist, which is that it outweighs. They say people so read policy arguments. It's a question of models and not it's a question of models, which is that if our model of our integration is better than theirs, then you should vote negative. Now, truth testing is the last thing they can go for in the 2R, but they've conceded that it's jurisdictional. It's kind of the 4 point that your paradigm literally says to reject discriminatory language and discriminatory language in all instances, which is that's constitutive. But if they say that their offense outweighs, then it's not. It proves that constitutivism isn't binding. Because weighing between constitutivism proves it's not binding. Now, the last thing I have to answer is URLs. Go there now. Counter-information, I only have to send the URLs of my evidence if they request it. Re-highlighting of NSDA 23 says that evidence is only needs to be URLs only need to be provided if requested independently. This is an independent voter for evidence ethics because they conveniently highlight they conveniently leave out things that are convenient to them, which proves that if they wanted URLs, I would have sent them, and I sent it in the email chain, which that solves 100% of their offense. Yeah, again, there's an independent voter for evidence ethics because they conveniently highlighted this part out, which is an integral to fairness. So if they go for fairness outweighs, then it's also independent offense. Look, this debate is very simple. They've conceded that normative justifications are bad. They've conceded if we win a link, then you should presume the case is false. You're winning the framework integration because the 1 error just dropped subject, they just dropped subject information in the golden rule. And if the 2 error tries to go for fairness outweighs, you remember, racism is an integral to fairness, which means that it must outweigh. The only other thing they can go for is truth testing, but they've conceded that truth testing is racist because if you were to say the N-word, that has nothing to do with the truth, falsity, of the resolution, you'd still be allowed to win, which is racist, and they concede that racism outweighs, which is that racism must outweigh constitutionalism because it's a matter constraint on your ability to evaluate the rap.
252. Say I conceded.
Root case if we win.
Okay, sure. less ULs than like 2 in our arguments. I'll try to sacrifice.
Okay.
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 Sure.
Alright.
Okay.
Conceded the evidence ethics standard of the shell is GG's. Extending interpretation debaters must include a UL stating that the evidence is formal book. They must have copies of it. The violation was uncontested as standards. First will respond to the NSU rules IVI here. It's incoherent. We didn't conveniently leave it out. That was the shell's our way of requesting for the evidence. You don't meet and we'll get another violation if you don't stand it. We'll concede that you meet on this standard, but it's not an IVI. Also independently, the next standard outweighs because it's evidence ethics in this one instance versus infinite evidence ethics violations if we win the next standard. So extend the next standard evidence ethics. Nobody got to check whether the court exists. They can just make up whatever evidence they want. Independent voter, it destroys the constitutional purpose of the as an educational activity. If you just make up a lie about evidence, remember it's 100% strength of the on IVI. They fully conceded it was in the 1 AR. They didn't realize because they weren't flowing around because they don't know what they're doing. They need offense and why not including the URL is good. That's obviously incoherent. There's definitely URL for at least one of them, proven by the fact that they did send the URLs after they don't have offense and they're competing. They're competing in terms, so they're losing the round. Extend this, stop the debater. The 4 times obvious. It's illogical to win for being competing in terms, so they're true, not Johnson after. They're losing this debate. They don't understand what competing in terms means because they better competing in terms, but they didn't read any offense into it. So we'll tell them they're competing in terms doesn't sell. It's obviously better if it's preemptively sent because otherwise you can't check until the 1 is over. We've asked them in cross, and also if we get to ask in cross, then it's because PvP game over for me because they can probably lie to every single one of the pieces of evidence. 4 minutes of prep time is not enough evidence as it's outweighs racism because all the racism links rely on the fact that all the stuff that they say is true. But if we win now, if we win this competing in terms argument, that means it's a question of models of debate. They say so themselves, and the 2 is a question of models of debate. So their model debate is that people don't send URLs, they lie about evidence all the time. Our model of debate is that we do have URLs. That is a prerequisite because obviously you can't debate out who's being racist and who's not being until you've established that everything said in the round is true, which means that we conclude at a methodological level. Our question is a question of a norm-setting model. We tell you it's competing in terms, which means that whoever has offense is winning, and obviously our interp concludes it comes first, which means evidence ethics outweighs racism. New case, no, this isn't part of the case. This is a new 1A3 that's directly responsive to the case, which means they don't get to weigh the content of the case given that we are indicting the form in which they are giving the case. They say we concede racism is an interlinked to fairness and it denies access. No, URLs denies access to fairness and conceded that fairness is magistrate the ability to evaluate the round. Well, that obviously they say it controls the interlinked to fairness. Well, so does evidence ethics because obviously you're not being unfair if you're just lying about all your evidence, which means that at best that racism debate is a wash, but we have proven that it's a question of model debates. Obviously, this precludes because there's no way they can prove the truth of their statements until we resolve the question of the shell. They say, we conceded a bunch of this cave framework stuff, but it's completely incoherent. We have a bunch of the golden rule stuff in there, so we'll extend them here. We'll extend their interpretation is wrong. They could have framed out the truth testing by reading an ethical framework of chose, but they chose not to. Debate shapes subjectivity. This is in the 1AR wrong. Voting that doesn't actually do anything. Debate is a game designed to win. Trump's all proven by the fact that tons of cases are read, but people still read policy after that. Directly responsive to the golden rule wrong. This is in the 1AR with 100% of these good ones. Otherwise, you make a wrong decision and internalize unfairly calling people racist. But the shell also operates under their model debate because you can't evaluate it until
and yeah.
Okay.